Good afternoon. This is a meeting of the Rules and Executive Nominations Committee. We're having public hearings this afternoon, and then we will be doing some re-referrals afterwards. We have a few bills and not a whole lot of witnesses, so I hope that we can move along, but I'm going to not time the sponsors, and we'll see how it goes. The first bill on the agenda is House Bill 182. Delegate Boucher. Do you have a panel?
Excuse me, ma'am, could you repeat that?
I said, I don't believe you have a panel.
No, ma'am.
Okay, please sit down and begin.
Good afternoon, distinguished body. Thank you, Madam Chair Healy, Vice Chair Holmes, and the most distinguished body of members of the House of Delegates. This is the amassing of the greatest intellect of this institution. It is a tremendous honor to be before you. I hope that helps. Before I get started, I want to give you two quotes. One is from the great James Madison, the father of the Constitution. The purpose of the Constitution is to restrict the majority's ability to harm the minority. James Madison. My second quote is from the father of political science, Aristotle. There is no great genius without some touch of madness. And I have to say he is quite true about that, for those who question my insanity for doing this. This bill today, House Bill 182, the Citizen Redistricting Convention, is about restoring true sovereignty to the citizens of Maryland. I think we all can agree that whoever controls the power of drawing the legislative districts is truly the sovereign of the state of Maryland. And at present, the citizens of Maryland do not draw the legislative districts for the General Assembly or the U.S. House of Representatives. The leadership of the Maryland General Assembly draws those districts. Therefore, technically, the leadership of this institution is truly sovereign over the citizens. This bill would put sovereignty in the hands of citizens through a citizen redistricting convention. Our nation has been plagued by the issue of gerrymandering since the Federalist era in 1800, after the first census was enacted and they had to draw new districts. That has created a conundrum ever since for over 200 years as to how to properly draw the districts to represent us in the legislative institutions. I myself have challenged the redistricting of the Maryland General Assembly all the way to the United States Supreme Court in 2012, created state Supreme Court case law on the issue, and had my appeal rejected by the state Supreme Court. And what the United States Supreme Court, what the United States Supreme Court continuously tells all of us that challenge these bills is it is not a judicial question. The question before us is a political question. Therefore, the solution lies within us as legislators. It is our duty to find a solution to the gerrymandering conundrum and ensure that districts are properly reflective of the citizens. The Citizen Redistricting Convention bill, which I propose, would allow citizens to be elected statewide, a total of 188, and I chose 188 to be reflective of the totality of the General Assembly at 188. And after the census, the population of each county would be determined how many delegates they would represent them in a Citizen Redistricting Convention based upon their population, with every political subdivision of the state, regardless of its size, guaranteed a minimum of 3 members in a delegation. So Garrett County or Kent County, regardless how small they are, they would at least have 3 members elected countywide at large on a nonpartisan ballot to represent the interests of that county at the table when drawing both the national and state legislative districts. The reason I believe that this is truly a genius solution is its simplicity falls upon the genius of our founding fathers when they created the United States Constitution. It is irrefutable that the United States Constitution is the greatest political science document in the history of mankind. And it was created through a convention represented by all the subsections of the whole. Every state was at the 1787 Constitutional Convention, except Rhode Island was a bit dysfunctional, but the other 12 came together. And they came together in compromise. And when the Constitution was originally produced, not everyone was happy with it. But in retrospect, we realized that the compromise was its genius. And that genius is how we need to approach the redistricting conundrum. That citizens from across the state need to be elected to come together representing their political subdivisions to ensure that gerrymandering does not take place. Also, I believe this is instrumental to ensuring the long-term diversity of this institution. And the only way for us to ensure that diversity into perpetuity is have citizens from all the political subdivisions elected to represent their interests. To date, historically, the redistricting process of the state of Maryland has excluded minorities and females predominantly. If citizens are elected from their subdivisions, we will have a massive amount of minorities and females at the table, never before seen in our history, to ensure that their interests and concerns are represented in the redistricting process. And I think this is a great bill. I think it'd be quite magnanimous of us as legislators to turn this responsibility over to the citizens. But the conundrum has been so complex that truly needs to be turned over to the citizens. After all, we are a democratically elected republic, and the principles set forth in this convention fall squarely upon the democratic republic principles set forth. And I think this is a historical bill. I think we as the state of Maryland have a chance to set an example for all other states. And I'm happy to share this bill with you. I want you to join together potentially in making this happen and set example for the rest of the state to ensure that into the future, the diversity of this institution is ensured by the diversity of the people that come together in this convention to draw our districts. With that said, I say thank you very much.
Thank you very much, Delegate. Are there any questions from any members of the committee for the sponsor? Seeing none, that concludes the hearing on this bill. Thank you very much.
Thank you, Madam Chair. And thank you, colleagues. Have a wonderful day.
Next, we have House Joint Resolution 1, Delegate Patterson. If you have a panel, please bring them up.
Good afternoon, Chair Healy, Vice Chair Holmes, and members of the Rules and Executive Nominations Committee. For the record, I'm Delegate Edith Patterson, co-sponsor really of HJ1, the House Joint Resolution affirming the Federal Equal Rights Amendment. This resolution or this legislation urges the federal government to publish the Equal Rights Amendment as a 28th Amendment to the U.S. Constitution, and urges the U.S. Congress to pass a joint resolution affirming the Equal Rights Amendment as a 28th Amendment. This will guarantee women equal rights under the U.S. Constitution, giving women the security of equality in pay, equality in job opportunities, equality under political structure, education, and healthcare, including reproductive health care. The Equal Rights Amendment states, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. For over 100 years, courageous advocates have fought to enshrine these words into our Constitution. The resolution before you today is one more chapter in this fight, and I hope you will join me and take a historic step towards guaranteeing equality on the basis of sex. Article 5 of the U.S. Constitution lays out 2 steps to make changes to its text. They include Congress proposes an amendment and the states ratify it. 2 steps. Despite the requisite 3/4 of the states ratifying the ERA, the federal government has not recognized states' action and has so far declined to finally certify and publish the ERA as a 28th Amendment to the U.S. Constitution. Unlike many other efforts to amend the Constitution, the Equal Rights Amendment has achieved the necessary number of ratifying states. Thus, under the plain language of the Constitution, it is fully ratified. 100 plus years ago, 100 years since the language was first drafted, it is far past time for the federal government to respect states' co-equal powers in the Article 5 constitutional amendment process as ratifiers. The principles of federalism central our country's governance demand this, and the rights and protections at stake that will be guaranteed by the ERA are too important for inaction. In response to federal inaction, many states have passed resolutions urging the federal government to certify and publish the ERA as a 28th Amendment. Senator Kelly and I introduced joint resolution which models the ERA affirming language passed in other states, but this does a bit more. Under our resolution, it makes clear that Maryland, as states that ratified the ERA, views the ERA as a 28th Amendment now that it has crossed the constitutional threshold. Our resolution today also says that in Maryland, we know that sex-based discrimination takes many harmful forms and that sex-based protections must be broad and expansive to protect us from harm. This resolution also has historical precedent. The General Assembly passed a resolution in the 1960s urging Congress to propose the ERA to the states for ratification. And we are continuing in that tradition of asking Congress to act with urgency. With this resolution, Maryland expects the federal government to respect our co-equal role in the Article 5 process and finally recognize ratification. And it calls on other states to take similar action. Lastly, Senate Bill 1 passed out of the Senate Judicial Proceedings Committee with bipartisan support. I hope that the House will do the same and take this historic step towards finally enshrining in our Constitution the principles that equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. I respectfully urge you to give this resolution a favorable report. Thank you for consideration. And Madam Chair, I would simply add a personal comment. As a product of a desegregated childhood, and more importantly, having a degree in science and biology that was not favorable in the 60s, I too experienced not only sexual inequalities based on my sex, but also on my race. So this bill, this legislation is personally responsible, and I encourage your favorable consideration. And I appreciate the advocates who are here today to offer testimony. Thank you.
Thank you very much, Delegate. We'd like to hear from your panel before we take questions from the committee.
Good
Please.
afternoon. I am
Again,
Marianne Gorman, Chair of the ERA Task Force for the Maryland Chapter of National Organization for Women. Thank you for this opportunity to testify in support of House Joint Resolution 1. Constitutional equality has been a core issue for NOW since its founding in 1966. Maryland now has actively pursued policies that protect Marylanders from sex-based discrimination and the violence that it feeds. Thank you, Delegate Patterson, for responding to the call of Maryland Now and 36 other Maryland-based organizations to introduce this ERA affirming resolution in the General Assembly this session. Thank you, too, to the 15 members of this committee who are co-sponsors of HJ1. I am here to ask the remaining 11 of you to at minimum vote favorably on this resolution and hopefully demonstrate bipartisanship in supporting the measure as co-sponsors. The ERA has a long history of bipartisan support dating back to the 1940s when both the Republican and Democratic parties added the proposed amendment to their platforms. 3 decades later, the 92nd Congress passed the ERA with an overwhelming bipartisan majority, over 80% of both houses. Today, the ERA continues to have tremendous bipartisan support with over 80% of voters, and that includes over 76% of Republican voters and over 89% of Democratic voters, reporting they would like Congress to affirm the ERA as the 28th Amendment. We are hopeful the Maryland House committee and floor votes on this resolution will reflect the bipartisan sentiment for constitutional equality held by an overwhelming majority of voters, as we saw in the Maryland Senate earlier this session. We urge you to set partisanship aside and make a strong statement to Marylanders that on the issue of sex equality, the Maryland legislature is united for the greater. Perhaps this can provide a model for the U.S. Congress when they consider the federal joint ERA affirming resolutions later this year.
Thank you so much for your testimony. Appreciate it. Next.
Good afternoon, Chair Healy, Vice Chair Holmes, and members of the Rules and Executive Nominations Committee. I'm Tazeen Ahmed. I'm the president of the Montgomery County Women's Democratic Club, which is one of the largest and active Democratic clubs in the state, with hundreds of politically active members and including many elected officials. And we urge you to pass 8J1 that clearly affirms that the Federal Equal Rights Amendment meets the requirements of Article 5 of the U.S. Constitution and ask Congress to finally certify and publish it as the 28th Amendment. Maryland has long been a leader in the battle for gender equality. We ratified the ERA 2 months after it was sent to the states for ratification by Congress in 1972 and enacted our own state ERA a few months later. And that's not all. There's precedence for the resolution before you today that dates back to 1961, when Maryland became the 4th state in the country to pass a bill urging Congress to adopt the ERA as a constitutional amendment. Maryland has been on the right side of history in the fight for gender equality, but the work is not done. Today we urge lawmakers to take up this cause again, because while Marylanders are fortunate enough to have a state ERA protections in place, without the federal ERA in our Constitution, our state constitutional protections could be jeopardized by federal courts, including the Supreme Court, or by Congress. And to maximize our impact, WDC has joined with Maryland Now, Free State Justice, and AAUW Maryland to create the Maryland Equal Rights Action Network, MERIN, to coordinate equal rights, the ERA advocacy efforts across the state. This network includes organizations from Garrett County to Talbot County, from local commissions for women, LGBTQ+ advocacy groups, Black women, university women, business professionals, and more. The time now. The ERA must be ratified and published as the 28th Amendment to the Constitution, and we ask for your support and strongly urge a favorable committee vote. Thank you.
Thank you very much. Next.
Good afternoon, Madam Chair and honorable members of this committee. My name is Katie Curran O'Malley, and I am the Executive Director of the Women's Law Center of Maryland. I come to you urging a favorable report on this resolution, not only as a woman, as a mother, as a daughter, and a sister, but as a human. I mean, this is really an issue of humanity, and making sure that this amendment finally becomes ratified is one that we should all share in. We've heard it's been much so a bipartisan issue in Congress, as well as just in our own legislature, having the Senate Joint Resolution pass in a bipartisan way. It's imperative that this is done, especially in light of the way the Constitution has been interpreted recently against women. The Constitution explicitly states that women and people across gender spectrum are equal to men, and to affirm that gender-based discrimination is unconstitutional. This is especially important now considering recent attacks on women's rights and the rights of members of the LGBTQ+ community. The ERA has enormous support among Democratic and Republican voters, and the concept of equal rights for all people should not be debatable. Enshrining this in our Constitution will guarantee that all of our citizens have equal protection under the law. Just recently, in March 2021, the United States House of Representatives voted to remove the time limit so that there could be consideration for Article 5, where it states that 2/3 passage of each House of Congress has to be part of ratification, as well as 3/4 of the states. And we now know since 2020, Virginia has ratified and satisfied that requirement. So this amendment needs to become part of our Constitution. As I stated, not just as a woman, I'm urging this, and as a mother and a sister and a daughter, but as a human, and I urge a favorable report. Thank you so much.
Thank you very much. Next.
Thank you. Good afternoon. My name is Camila Reynolds Dominguez, and I'm from Free State Justice, and I helped found the Maryland Equal Rights Action Network. 36 organizations signed on to a letter from the network urging legislators to introduce this resolution, which mirrors language passed in other states. The group represents Marylanders of all backgrounds from across the state, and our message was clear that we need the ERA. This resolution urges the federal government to respect Maryland's constitutional powers as a ratifying state and finally certify and publish the ERA. And in addition to all the things that you've heard about the ERA in this resolution, our state's language does a bit more that's directly impactful to state law. This past summer, the Maryland Supreme Court held in a case named John Doe v. CRS that under Maryland law, sex-based discrimination does not also encompass discrimination based on sexual orientation or gender identity. This holding is directly at odds with the U.S. Supreme Court precedent in Bostock v. Clayton County, where Justice Gorsuch held in 2020 that it is impossible to discriminate against someone because of their sexual orientation or gender identity without simultaneously discriminating against that person because of their sex. The Maryland Supreme Court's rejection of Justice Gorsuch's reasoning is clearly illogical and simply cannot stand. In conjunction with several other bills introduced this session, the resolution before you today helps course correct the state Supreme Court's disastrous decision. In the final whereas clause, the resolution articulates a broad understanding of what constitutes sex-based discrimination under Maryland law, squarely rejecting the Doe Court's misguided decision and clarifying that these protections, sex-based protections, also cover gender identity and sexual orientation. This is a critical statement for the General Assembly to articulate this session via the resolution. Passing this resolution is the duty of the Maryland General Assembly, which must ensure that the federal government respects our state's rights under the Constitution. We urge this committee to give this resolution a favorable report, reject the Doe v. CRS decision, and take one more historic step towards enshrining the ERA in our Constitution.
Thank you very much. Is Nashana? I have one more favorable in-person witness. Thank you so much.
Good afternoon. My name is Nashana Kess, the Executive Director for the Maryland NAACP, and we stand in favor of this resolution. Today, we gather here with a purpose that resonates deeply with the NAACP to ensure equality for all, eliminating race-based discrimination, and championing the well-being of every individual. Our vision is clear: a society where each person enjoys equal rights without the burden of discrimination. In this spirit, we urge you to consider the significance of HJ1, a pivotal resolution advocating for equal rights amendment as a 28th Amendment to our Constitution. This is not just about legal formalities. It's about affirming sex-based equality as a fundamental right, bridging the gap that has long existed in our quest for true equality. The necessity of this amendment becomes starkly clear when we confront the realities faced by women, particularly Black women in our country. The disproportionate rates of intimate partner violence against Black women and the alarming statistics of women killed by guns in the U.S. underscore the urgent need for comprehensive protections against gender-based discrimination. By supporting this resolution, we are taking a critical step towards rectifying these injustices. The Equal Rights Amendment offers a beacon of hope, promising a future where gender equality is not just an aspiration, but a guaranteed right. The Maryland State Conference of the NAACP supports this resolution. We call upon you, the stewards of our society, to join us in this cause. Let us move forward together, committed to creating a world where equality is the reality for everyone, regardless of race and gender. Thank you.
Thank you very much. Are there any questions for the sponsor or any of the witnesses? Delegate Shalega.
Thank you, Madam Chair. Thank you all for being here. And of course, as a mom and a grandmama of girls, I care very much about women as well. I have a couple questions. The first one would be, I guess, for the sponsor, Delegate Patterson, welcome. Can you tell us, after I've read this, is this about women? And if so, can you tell me what a woman is? Can you define a woman?
Thank you for the question. Luckily, you want a scientific answer? My major, I mentioned earlier, is in biology. So I'm not going to say a woman, I will say a female. Genetically, a female is one who is born with 2 X chromosomes.
Okay, thank you. So it is the typical female that we understand it to be, because there's some other language in your resolution that may counter that. So I'm very pleased to hear you say that. My next question, I don't know who it would be for, but I've done some research into this. And, you know, in 1972, this resolution was sent to the states. That's 52 years ago. I'm plenty of people in the legislature that are not 52 years old, so they certainly wouldn't have remembered it. And I was a young child. They had a 7-year deadline. And then they got a 39-month extension to 1982, and it had never passed. So in 1986, Gloria Steinem said very vocally on Oprah Winfrey that the ERA is dead. So how can you tell us it's not when this time frame has passed? Not enough states had ratified it, and this is vastly different than the original one that was passed.
Well, I'd be happy to answer that.
Go ahead, Marianne, and then I can follow up.
Is that okay? Sure. Okay, I'll give you my answer. This is not from a judge or.
No.
But that's a really great question, and thank you for asking it, because it comes up a lot. Yes, originally there was a time limit that was included in the preamble to the amendment in 1972, and there's a lot of gray area around that. Many constitutional scholars will tell you that the Congress never had the authority to put a time limit on an amendment, and that's for the constitutional scholars to debate. But I just wanted to put out there that that's up for the debate, whether that was allowed to begin with. I think what's important here is that Congress, at one point in 1979, extended the time limit.
Mm-hmm.
And there's no reason Congress can't extend the time limit again. So the idea, I can't speak also to Gloria Steinem's basis for calling it dead, but it certainly is not dead. I don't know if you were around on February 19th in Annapolis, but you would have seen that the ERA is certainly not dead. It's very much alive. And what's left for it to be published is 2 resolutions in the federal Congress right now, joint resolutions in the Senate and the House, and in which the Congress can affirm and that the ERA is valid and officially remove the time limit, while there's still debate whether the time limit was valid to begin with.
Judge, thanks. Thanks, Delegate, for the question. So Gloria Steinem, although I admire her, she's not a legal scholar, nor does she have legal authority to determine whether or not an amendment is or isn't valid. And the time period that was put for getting this passed was not in the amendment itself. It was just in the preamble. So actually, Congress has the ability to erase the time limit, which they actually did March 17th in 2021. The United States House of Representatives voted to remove the time limit in a vote of 222 to 204. So right now it's up to the United States Senate, and there's a joint resolution there to go ahead and do the same thing. I believe Senator Murkowski and Senator Cardin have been spearheading that effort. So when that happens, with getting that removed, then the amendment itself is really the meat of whether or not this can be published to become our 28th Amendment. And we already have Virginia, who has signed on now, I believe is the 38th state, And we have approval by, so that's 3/4 of the states. We actually have 38 states who have ratified the amendment.
Didn't some withdraw their support?
They,
Six?
actually, Mary Ann's a very good expert on the withdrawal. They didn't, they withdrew, but they hadn't been ratified, correct? What was-
That's a really good question too. The time limit seems to be more of a sticking point, but it's good to get that out there. Yes, some states withdrew their ratifications, but there's no precedent for a state being able to withdraw a ratification. In fact, in the 14th Amendment, 2 states withdrew their ratifications. And if you look in the books of the published amendment, you'll see they're listed as ratifying states. That doesn't seem to, that's a really good question. It doesn't really seem to be something that's holding up among.
Yeah, that may come into question. And finally, and thank you for your indulgence, Madam Chair. I would contest that this is far different than the 1972 ERA that came through. And I would point you specifically to pages 4, lines 17 to 23, where it speaks about much broader than women as declared by Delegate Patterson, which includes legal equality and protection from discrimination on the basis of sexual orientation, gender identity, gender expression, pregnancy outcomes, and decisions regarding reproductive health care or other aspects of an individual's bodily autonomy. Now, therefore, be it. So that clearly in 1972, some of those words didn't even exist in our dictionary. So I think if you're going to ratify the amendments, you should maintain the purity of the language that was originally brought forth. So thank you, Madam Chair, for your indulgence.
Thank you, Delegate. Delegate Collison has a question. Thank you.
Thank you, Madam Chair. So I guess I have a couple of, I think, brief questions. One was, when did Virginia actually ratify? 2, now our amendment, our set of whereases do not change the original amendment, correct? So we would still be advocating for the original amendment. We would just be speaking on behalf of Marylanders in terms of our consideration of equal rights for every person. And so that's a statement, not a question, but I just accept to make sure that we're not changing the amendment. And the third one is, are there other states who are working? You all have done a fabulous job, and the organization and advocacy around this in the last year has just been tremendous. Thank you, Delegate Patterson and your team. Is this a national effort? Are other states working on this? And if so, like where, who? And those are everything I need to ask.
So Delegate, I can answer when Virginia ratified. That was January 27th of 2020. And if you want to follow up on any other specifics about the other states, go ahead.
Sure. 5 other states have passed similar resolutions. I think I can name them. California, Colorado, Illinois, Hawaii, and Nevada. Thank you.
Nice.
So 5 other states have passed similar resolutions, and they continue to be introduced. And then just following up on your comment, I just want to clarify that the language in the Equal Rights Amendment has not changed from 1972 to today. It's the same language, and it does not mention women. The word woman is not in the amendment.
Okay, thank you. And 2020 was way after the time frame.
Yes.
Yeah. Thank you, Madam Chair.
Thank you very much. And are there any other questions from the committee? If not, I have one little thing I would like to also add, which is I'm interested, especially that Virginia finally moved on this. One of my very earliest forays into politics was when I lived in Virginia in 1976, and I went to a demonstration in Richmond in favor of the NRA, wearing a T-shirt at the time that said 200 years is long enough. And now it is all these years since then. So thank you so much for coming before us today. And we don't have any other witnesses in person. There is written testimony in the record, as well as other people who have stated whether they're for or against. So with that, that concludes the hearing on House Joint Resolution 1. Thank you.
Thank you.
4. Delegate. Bandari, I'm sorry. I just didn't see your name on here. Thank you.
Madam Chair, Vice Chair, and honorable members of Rules and Executive Nomination. For the record, I'm Delegate Terry Bandari. I'm here to advocate for the passage of House Joint Resolution 4, known as the Maryland Safe Artificial Intelligence Act. This resolution is a testament to Maryland commitment to ensuring that the development, deployment, and use of artificial intelligence, AI, in our state are conducted safely, ethically, and in alignment with democratic values and civil rights. The rapid advancement of AI and automated system brings within a lot of opportunities to improve our lives and work, from enhancing agricultural efficiency to revolutionizing industries through advanced data analysis. The potential benefits are immense. However, these advancements also pose significant challenges to democracy, privacy, equity, and the rights of our citizens. Instances of unsafe, ineffective, or biased AI system in critical areas such as healthcare, hiring, and credit decisions have highlighted the urgent need for a guiding framework to protect our citizens. The blueprint for an artificial intelligence Bill of Rights developed by the White House Office of Science and Technology, policy under President Joe Biden's administration, provides a comprehensive set of principles designed to navigate these challenges. It emphasizes the importance of creating AI systems that are safe and effective, protect against algorithm discrimination, ensure data privacy, and provide transparency, accountability, and avenues for human oversight. By affirming our commitment to this principle through a House Joint Resolution 4, we position our state as a leader in the responsible development and use of AI. This resolution is not just a statement of intent, but a call to action for us to examine and implement legislation and policies that embody these principles. It urges us to safeguard our citizens against the risks associated with this automated system while harnessing the benefits with this technological offer. Our commitment to aligning with President Biden's vision for safe AI and the principle outlined in the Artificial Intelligence Bill of Rights demonstrate our dedication to advancing this technology and, in the meantime, protecting our citizens. I urge this committee to support House Joint Resolution 4. Let us lead by example and show the nation that our state is committed to fostering an environment where technology serves the public good, grounded in our shared values of democracy, equity, and justice. Thank you for considering my testimony on this crucial matter, and would ask the favorable report.
Thank you very much. Are there any questions for the sponsor? I see none. Thank you very much, Delegate.
Thank you.
All the testimony we have is written, and we have a number of people who have signed up favorable and unfavorable for the record, but that concludes the public hearing for this bill. Okay, so next is House Joint Resolution number 5. Delegate Martinez, I'm sorry, I didn't call your name.
Okay. So, good afternoon, Madam Chair and colleagues of the Rules Committee. For the record, I am Delegate Ashanti Martinez, here to present House Joint Resolution 5, the commitment to free speech, academic freedom, and open public discourse. Freedom of speech was created as a constitutional right because our founding fathers agreed that having differing opinions and perspectives is okay, but it is our right to also be able to express them in a safe and respected environment. And that any attempt to try to shun, censor, or provide consequences on the basis of opposition to that speech would only create an environment of fear. I believe that disagreements are healthy. They encourage dialogue and empathy, understanding, and a difference and thought should be celebrated. What we are seeing on our college campuses in particular is why I introduced this resolution. Many of you may be aware of my background in organizing and movement building and activism. And so I'm very aware and tapped in to what's happening on college campuses. And those that are very critical of foreign governments right now are being retaliated against and silenced. And so this resolution to me affirms the right to make good trouble. Some of you have been in my office. Right above my picture of John Lewis that says "get in good trouble" is my first arrest citation from when I was arrested in front of the Capitol for protesting for immigration reform. This is who I am, and affirming these rights through this joint resolution is something that I'm urging all of us to do. I firmly believe that no one is above critique, and that includes all of us, as well as foreign governments. You'll see in the resolution that there is a particular entity outlined, and that is Israel. I have no hate or disdain towards Israel. I believe there should be a two-state solution. But I also know that those that have spoken up against the atrocities that are happening in Gaza have been criticized and pinned out, critiqued, blacklisted, doxxed, and that cannot stand. And so I ask for a favorable report on HJ5, and I thank you all for your time today.
Thank you very much, Delegate. Do you have a panel?
Yes, right here.
We'll listen to your panel and then take questions from the committee.
Thank you so much.
Good afternoon. My name is Evie Frankel, and I'm here to request a favorable report on HJ5. HJ5 asks the state of Maryland to affirm its commitment to free speech, academic freedom, and open public discourse. Our commitment as a state is wavering, and it is deeply troubling. It saddens me to say that Montgomery County is a mess. Public officials privately will tell you that everyone is afraid of being accused of anti-Semitism. This is true for this body as well. I have been told confidentially that everyone here is afraid to talk about any of the bills pertaining to anti-Semitism, Islamophobia, Israel, ceasefire, or free speech because they are afraid of being accused of anti-Semitism. Everyone in this room knows that this is true. We are in a time reminiscent of McCarthyism. We are coming close to naming names. Who is an anti-Semite? A recent Democratic election at a local teachers union was picketed by groups who, while telling teachers to forego foreign affairs, meaning ceasefire, waved the Israeli flag. I am the daughter of Holocaust refugees. My parents and infant brother escaped Vienna, 1938. I am the granddaughter of non-survivors. My grandparents were murdered at Auschwitz. I am the niece and grandniece of camp survivors who bore scars forever after. Will I be called an anti-Semite after this testimony? Feeling unsafe and being unsafe are not the same. Anti-Semitism is real, but it is not in the discussion of Palestinian lives lost. It is not in the criticism of the policies and actions of the Israeli government. It is a part of the broad broom of white supremacy, centuries old, and now again sweeping this country and many other parts of the world. It is dangerous and vile. We Jews have allies.
Thank you so much for your testimony. We appreciate it. Do you have any other people on your panel, Delegate?
It's just us two.
Okay, well, then we'll take any questions from the committee for the sponsor and his panel. Seeing none, I thank you very much. We have other witnesses.
Awesome. Thank you.
Okay. Yes. Nashana Cass, please. And I'm going to call up the other, that we have a virtual witness, Shelley Cohen Fudge. Is she here? She's not here. Okay, she didn't come in. And Darren Clark. And Sarah Milky. Thank you. She already spoke.
Thank you. My name is Nashana Kess. I'm the Executive Director of the Maryland NAACP, and we stand in favor of this resolution. Resolution HJ5 This resolution is crucial, reaffirming our commitment to free speech, academic freedom, and the open exchange of ideas, particularly on matters of foreign policy. The First Amendment of the United States Constitution enshrines the freedoms of speech and expression as fundamental rights, essential for a thriving democracy. These rights ensure that every voice, especially those historically marginalized, can be heard and can influence the direction of our society. Historically, people of color has leveraged these freedoms to challenge injustice and advocate for equal rights, shaping a more inclusive and equitable America. From the eloquent appeals to Frederick Douglass to the impassioned speeches of Martin Luther King, the power of voice has been a catalyst for change and progress. Moreover, academic freedom can open discourse are indispensable in educating and empowering our youth, ensuring they can explore diverse perspectives and develop their own informed viewpoints. This resolution supports an environment where all Marylanders, regardless of background, can freely express their opinions and actively engage in public discourse. The urgency of this resolution was underscored by the resignation of Dr. Claudine Gay, Harvard University's first Black president, who stood firm on the principles of free expression. This incident highlights the need for protections against efforts to silence voices through intimidation or financial coercion, reminiscent of the challenges faced during the Jim Crow era. By supporting this resolution, the Maryland General Assembly would not only reaffirm essential democratic principles, but also champion a more inclusive, informed, and engaged society. I urge you to pass this resolution, upholding our collective commitment to freedom, democracy, and the right of every individual to partake in shaping our future. Thank you.
Thank you very much. Are there any questions for the witness? Seeing none, thank you. We have two unfavorable witnesses, both in person, and that would be Darren Clark. Is he here? Going once, going twice. Okay, he's not here. And the last in-person witness is Sarah Mickey, M-I-C-K-E, Sarah, in person, unfavorable. Thank you so much for coming up.
Good afternoon, Madam Chair and members of the committee. I'm Sarah Mickey, Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore, its agencies, as well as the organized Jewish community of Greater Baltimore, here today in opposition of HB 5, another resolution brought by the sponsor that seemingly is innocent, but in reality targets the only Jewish state in the world, Israel. This resolution lists one foreign government, Israel, by stating that the General Assembly of Maryland opposes any efforts to infringe on the constitutionally protected right to criticize foreign governments, including the state of Israel. There are already laws in place that protect against free speech, academic freedom, and open public discourse. This resolution is not only unnecessary, but its explicit inclusion of only Israel among all the nations in the world makes it clear its actual intent. By singling out criticism of Israel as uniquely worthy of this protection, this resolution seems to suggest that Israel is the only country whose criticism is worth the protection of free speech. Many may disagree with certain policies of any foreign government, and they are free and open to speak against those policies. By only naming Israel, the true objective of this unnecessary resolution is clear: to target the Jewish state. For these reasons, we ask for an unfavorable report on HJ 5. Thank you.
Thank you. Are there any questions for this witness? Seeing none, thank you very much. The rest of the testimony is either just a statement for or against, or there might be a little bit of one or two written, but there's no more in person or virtual. So that concludes the hearing for this piece of legislation. Thank you very much. Have a good day. Next, House Joint Resolution 7, Delegate Ruth.
Thank you, Madam Chair, Mr. Vice Chair, members of the committee. For the record, I'm Delegate Sheila Ruth, here presenting House Joint Resolution 7. Although HJ 7 is a resolution, it's not just an expression of values or an appeal to another body. whether HJ 7 would accomplish something that only the Maryland General Assembly can do, and that is correcting the mistake of our predecessors and adding Maryland to the 28 states that have already ratified the Child Labor Amendment to the U.S. Constitution. Let me explain. If, like me, you have been concerned about states that have been rolling back child labor protections across the country, this is something that we can do a very small thing about. On June 2nd, 1924, against a backdrop of concern about exploitation of children in dangerous work in factories, Congress, by the required 2/3 majority, proposed an amendment to the U.S. Constitution to give the federal government the ability to regulate the labor of children. The text of the proposed amendment read as follows. Section 1, the Congress shall have the power to limit, regulate, and prohibit the labor of persons under 18 years of age. Section 2, the power of the several states is unimpaired by this article, except that the operation of state laws shall be suspended to the extent necessary to give effect to the legislation enacted by Congress. Prior to this, Congress had made 2 attempts to protect children from harmful labor. The Keating-Owens Act of 1916, which regulated the interstate sale of goods produced by children, and then in 1918 with a tax on businesses employing children. Both were struck down by the Supreme Court as unconstitutional under the Commerce Clause, leaving a constitutional amendment the only option available to Congress. After Congress proposes an amendment, it must be ratified by 3/4 of the states to be added to the Constitution. Very quickly, within just a few years, the child labor amendment quoted above was ratified by 28 states, but fell 10 short of the 3/4 needed to add it to the Constitution. After that, progress stalled for several reasons. One, a campaign of disinformation that the amendment would take away the rights of parents to control the education of their children. Second, the enactment of the Fair Labor Standards Act of 1938, which set minimum age limits for employment of minors in various conditions. And then third, the Supreme Court upheld the Fair Labor Standards Act in 1941 in United States versus Darby Lumber Company, essentially reversing the earlier 1918 decision. So after passage of the Fair Labor Standards Act, for a time, it seemed that the amendment was no longer needed and no additional states ratified. However, today, we are seeing an assault on labor protections for children that makes the amendment as needed today as it was 100 years ago when it was first proposed. According to the Economic Policy Institute, 28 states have introduced bills to weaken child labor laws since 2021, and 12 states have enacted them. The Fair Labor Standards Act remains in effect, but because much of the actual implementation was left to the states, states have enacted laws that in effect roll back child labor protections, allowing children to work in hazardous conditions or work long hours during the school year. Some of the new state laws, such as Iowa's law enacted last year, allowing teens as young as 14 to work in hazardous occupations, may actually be in violation of the Fair Labor Standards Act. To make matters worse, last year, Justice Thomas wrote a concurring opinion in the Sackett versus EPA case. That's the one that eviscerated the Clean Water Act. And Justice Gorsuch concurred with him that made the case that Congress's authority under the Commerce Clause is limited, which was very similar to that earlier 1918 decision I mentioned. If this argument ever found its way into a future Supreme Court decision, it could gut the ability of the federal government to regulate child labor and essentially overturn the Fair Labor Standards Act. Today, the Child Labor Amendment remains 10 states short of the 38 needed to ratify it. There is no time limit on this amendment. The Maryland General Assembly didn't just not ratify this amendment, they actually voted on March 18th, 1927 to reject ratifying the amendment. So it didn't just die a quiet death in committee. Our predecessors actually took a vote and decided to be on the record as being against child labor regulations. HJ 7 would rectify that mistake and place Maryland on the record as ratifying the amendment, bringing the number of states one state closer to the 38 needed. We are not alone in this. Since 2018, resolutions to ratify the Child Labor Amendment have been introduced in Hawaii, Rhode Island, New York, Minnesota, Nebraska, and Connecticut. And in Hawaii, it passed the state Senate twice with bipartisan support. And I will also note that this amendment has the support of the Maryland State and DC AFL-CIO. You should see a letter in your testimony with that. It also has the support of the National Child Labor Coalition. They unfortunately did not click the save button when they uploaded their testimony, so you don't have their testimony. But the Child Labor Coalition has members including Human Rights Watch, the National Education Association, UNICEF USA, and World Vision. So all of these organizations support this. And if, like me, you don't think that children or teens should be working in meat packing plants or 8-hour night shifts during the school year, please find favorable for HJ7. And with that, I'm happy to answer questions.
Are there any questions for the sponsor of this bill? Seeing none, we have no other in-person or virtual witnesses. All the rest of the testimony is either just a simple statement, yes or no, or some written testimony, including from the AFL-CIO. So thank you so much. That concludes the hearing on House Joint Resolution 7. Now we'll go to the last bill of our afternoon, House Joint Resolution 9. Delegate Solomon.
Thank you, Madam Chair. Good afternoon, everybody. Thank you for the opportunity to present on House Joint Resolution 9, which would declare the state of Maryland's support and consent to admitting Washington, D.C. to the Union as a state of the United States of America. For the record, Delegate Jared Solomon, I appreciate you all being here and for the opportunity again to present this legislation. And I just want to start off by thanking my partner in the work on this legislation, on the resolution, Delegate Ivey, as well. This is the fourth time, we think, in recent history, that we've introduced a resolution supporting DC statehood. And this is the largest number of co-sponsors that the resolution's ever received. And so just want to go on the record for stating that and appreciate the support from so many of our colleagues. And it's actually, this resolution is kind of enmeshed in Maryland history. The most recent chair of the House Oversight Committee was a former member of this body, Chair Elijah Cummings, who was the member of Congress who shepherded the Washington, D.C. Admissions Act through Congress during 2020. So this resolution is connected in a number of different ways, and I'm not going to get into the sort of constitutional issues, although I know we've got a lot of great legal scholars on the committee who I'm sure would love to debate it. There's information in my written testimony, but I did just want to kind of point out a couple of reasons why, resolution specifically on DC statehood would be particularly important to Maryland. And the first is the common wisdom and conversation around DC statehood is often, why doesn't DC just become part of Maryland instead of making it a state? And in 2016, there was actually a vote by DC residents, and by 86% margin, they voted for statehood and specifically rejected becoming part of Maryland. And for those of you that represent jurisdictions around the state, if somehow we absorbed Washington, D.C., it would actually become the largest city in Maryland. And I think we have enough of our own issues rather than having to take on issues of another jurisdiction that has its own distinct culture, heritage, history, and community. And so I think it's really important for Maryland to clearly say, you are not intended to be part of our state. You're intended, we believe, to be independent and on your own. And so that's the first reason. The second is we really need, as a region, a partner in governing. For those of you in particular who represent areas where the metro is important, we know that the conversation around metro funding is a partnership between DC, Maryland, and Virginia. And whether it's metro funding or other regional issues, when we negotiate with a partner, again, when we negotiate with Virginia and the Virginia legislature or the Virginia governor, we know that when the legislature says they're going to do something and it passes, that becomes the law of the land. Well, in DC, I think as most of you probably know, all of their past laws are subject, including their budget, is subject to congressional oversight. So there's a 2-week review period for any bill. This has been in the news quite a bit of late around some of their criminal justice issues. Congress can veto them, essentially, and say, nope, even though you have an elected body, you have citizens, you have over 700,000 citizens that participate in that process. We are going to tell you, as folks who do not represent this community, how you should be spending your money or what your laws should look like. So again, in the interest of regional participation and regional governing, it makes us better, makes Maryland stronger when we know we have a partner that can actually govern and hold themselves true to their word. The last piece, unfortunately, is something that I think many of us witnessed firsthand, in January 6th. So because DC does not have a governor or is not a state, the DC mayor cannot independently call up their National Guard. The National Guard has to be called by the federal government. And so our National Guard in Maryland was actually called up because there was a disagreement between the city of the District of Columbia and the federal government on January 6th of 2021. And so if DC were an independent state, the governor or the mayor would then become governor under the plan and this legislation, the legislation that's being considered in Congress, and the governor would then have the authority, like in all 50 other states, to be able to call up the Guard. This is the path that the 37 other states in the union that have been admitted since the founding of our nation have taken. And we are really proud to join with thousands of other legislators across the country who have joined in a DC statehood compact, essentially to send a message to Congress that they believe, again, that DC should become a state. And, we think this is important. 7 of our 8 members of our congressional delegation in the House are co-sponsors or sponsors of HR 51. Go figure, they picked that number, or Senate Bill 51. Both Senator Van Hollen and Senator Cardin are original co-sponsors of the legislation in the Senate. And with that, happy to take questions and would urge a favorable report. Thank you, Madam Chair. Thank you, members.
Thank you very much. Do you have a panel?
No, it was just written testimony that was submitted.
Okay, thank you very much. We have a question from Delegate Buckle.
Thank you, Madam Chair. Thank you, Delegate Saltzman. I have a question. I'm a relatively blunt individual. I think we all understand why this bill or the proposition of the District of Columbia becoming the 51st state isn't going anywhere, because it would inalterably change the composition of the United States Senate. One way that it would not is if you were to take Montgomery County and Prince George's County, the enclosed suburbs, Maryland suburbs of the District of Columbia, and make them part of the new state of the District of Columbia, which would then dramatically change the political calculus, would it not? Would you be willing to do that, where you live, to say, hey, we'll begin new state? Be a lot of political power, frankly, for politicians from Montgomery and Prince George's County. It would change the calculus for the state of Maryland, and would probably, I hear a lot about the DMV. I went to college in the DMV. I worked there. I like it. People who live in Baltimore, they're not part of the DMV. People who live in Western Maryland and the northern parts of Maryland, the Eastern Shore, it's not the DMV. Would you be willing to kind of create the DMV as a state, which I think makes a lot of sense?
To my good friend from Western Maryland, who I know has his own thoughts on Western Maryland's place in our state and in the broader union.
Right.
I would love to have this debate over, a beverage of some sort, but I think, again, in the resolution that we have before us, we are trying to represent and be good neighbors to our jurisdiction to the south, and make sure that the will of the people of the District of Columbia are represented in Congress.
And if we made the District of Columbia its own independent state, would it be the smallest state in the union or the second smallest?
It would not, actually. It would be larger than, population-wise, it would be larger than Alaska and Wyoming and
Alaska
Vermont,
and Wyoming.
excuse me.
And Vermont. Okay.
Depending on which year statistics you look at.
Okay. Thank you.
Are there any other questions for the delegate? Delegate Szeliga.
Thanks, Madam Chair. I might second my colleague from Western Maryland. I represent Baltimore County, and we might embrace that. So it wouldn't just be Western Maryland, but I would fully support that. And I think the folks from the Eastern Shore and Southern Maryland would love it too. So maybe add that to your list of next year's resolution. Thank you.
Duly noted.
Delegate Lewis.
Thank you, Madam Chair. No, not at all. Look, my district borders the district, and I think that I really appreciate you sponsoring this, because without their own ability to really self-determine themselves, I think a lot of people that was formerly known as the Chocolate City, frankly, are being forced out and coming into the Washington suburbs, which also means that if they need help, that means that Maryland voters, Maryland taxpayers have to support these folks when they fully want to stay in the District of Columbia. And I think we should empower them to do so. I think it's a great idea. So more of that, isn't that so?
Indeed. And Delegate Lewis, thank you. It was really important. My district borders the District of Columbia, as does Delegate Ivy's, and it was important for us as neighbors of the district to make that point.
Yes, Delegate.
Thank you. And just to add to the conversation, that drink that you offer, I will pay for it.
Sounds like a lovely summit. Thank you.
All right. Any other questions for the sponsor of this resolution? Okay, see, now we will move on to, we had a virtual witness in favor, a US Senator, Paul Strauss. Senator? No, he's the one that's not here. I'm sorry. Virtual, Adkit Jane. There you go, Mr. Jane.
Hi, all. Can you hear me?
Yes.
Thanks for letting me speak. So my name is Ankit Jain. I live in Washington, D.C. I am running for D.C. Shadow Senator for the seat that would be a partner with Senator Strauss. And I am currently in my day job of voting rights attorney with Fair Vote. I'd like to express my support for this resolution. I think it is both important for the national fight for statehood for the people of D.C. and it's important for Maryland as well. And I'll start with the people of DC. I think that this legislature expressing their support for DC statehood is actually more important than any other legislature doing the same thing, because as the delegate pointed out, a lot of the times you hear the talking point, why doesn't DC just become a part of Maryland? And I think it's important for the people of Maryland to make clear that they don't want DC to be a part of them, just as the people of DC don't want to be a part of Maryland. We have our own problems, we have our own history, we have our own culture, and neither side wants to join the other. And I think it's important that Maryland make that clear to resolve this talking point that comes up again and again whenever DC statehood is pushed forward. And I know you talked about the constitutional concerns. I won't go into detail about that either, but I think it is important to resolve a spurious but often brought up constitutional concern about DC statehood that this bill has passed. Make it clear you don't support retrocession and that the constitutional concerns are addressed. Now, on the point, I just want to say that it's not just a symbolic thing. You know, I think this is actually pretty important on the merits in terms of like getting support and making it actually happen. Second thing I'll say is that it would really be beneficial for the people of Maryland as well for DC to be a state. We face a lot of the same problems you do. You brought up traffic, metro. A lot of these problems are faced by both jurisdictions. If we had 2 more senators from Washington, D.C. Fighting for federal solutions, federal funding to fix these problems, that would make a real impact. I think we could actually solve a lot of problems that the people of Maryland themselves are facing. So thank you so much, and I ask you to report this resolution favorably.
Thank you very much. Are there any questions for the witness? Seeing none, thank you very much. That concludes the oral witnesses. We had everyone else has either signed up for or against or has provided written testimony. So that concludes the hearing on House Joint Resolution 9. Thank you, Delegate. At this point, members of the committee, we're going to go to the voting part of our meeting, which is re-referring bills to the standing committees. The list of bills that you have on your agenda was provided by the various committee chairs where the bills will be going. Delegate Holmes will make the motion.
Thank you, Madam Chair. I move favorable to have the following bills re-referred to the to the appropriate committee. HB 1463, HB 1488, HB 1489, HB 1490, HB 1503, HB 1514, HB 1517, HB 1519, HB 1521, and HB 1522. Move favorable and moving the referrals, Madam Chair.
It's been moved and seconded. All those in favor say aye. Any opposed, say no. The ayes have it. These bills will be re-referred to the appropriate committees. That concludes our business for today. Appreciate everybody who could be here. For the public, there were other committee meetings going on. Some of the members had to attend, and so we couldn't have a full house this time. But I appreciate everyone showing up so that we had a quorum to hear these important pieces of legislation. And